So let's start this. Friends, good evening. Welcome back to the Mehta and Mehta series of webinar on insolvency, decoding of IBC with Mehta and Mehta insolvency. And today, as you know, our topic is always that recent judgment, recent important judgments under the insolvency and bankruptcy code, which we also cover the disciplinary cases in that. We try to cover last 15 days, but now we have covered many things, many cases, all are covered. So we are covering old cases in disciplinary, right, Urvashi?
Yes, ma'am.
Okay. And so welcome all. Thanks for your support. The intention in IBC is that as regards code, it is getting updated. That also amendment we are keeping in mind and taking here. So updation will be also there. But as on today, as all concerned people knows that judgments are very crucial for IBC practice, implementation, and execution. So friends, again, this time we have with us two lawyers and also one of our IP colleagues also. So I will welcome Mr. Devarajan and Mr. Dweep Joshi for this webinar. Thanks for your time, Mr. Devarajan and Mr. Dweep. To briefly introduce Mr. Devarajan, I know Mr. Devarajan has not given me formal information, but I take it as a senior professional colleague, as an insolvency professional, and as also an advocate, practicing advocate, and practicing company secretary, 3 professions. And it's really pleasure, Mr. Devarajan, to you have here. I don't know additionally if anything you have. At present, I know this as your friend. So I welcome Mr. Devarajan. Friends, he is here to share his knowledge, experience, and expert comment on the subject. Thanks for your time. Also, I appreciate and welcome. Mr. Dweep has also said that no formal introduction will start that. But I'll appreciate his humbleness, and I'll say that Mr. Dweep is also a company secretary and practicing advocate. And he practiced also in insolvency and corporate law. So welcome, Mr. Dweep Joshi here. I'll request Mr. Devarajan and Mr. Dweep to say a few words on the IBC for 1 minute or 2 minutes, and then Urvashi, you can start your presentation. Yeah, over to Mr. Devarajan. Okay. So we have introduced you, Mr. Dweep. We have also introduced you.
Thank
you. Since as your humbleness, you both has not given formal introduction as such. So I have introduced as a friend at practicing advocate and practicing CS and IP. You can add whatever you want. And what I'm telling is that I request both of you to give 1 minute, what on the topic or what you want to say on IBC topic as such. And then we will start our formal presentation. So first over to Mr. Devarajan.
Hi, good evening, everybody. First of all, I'll thank the team of Mehta and Mehta for having invited me for this particular webinar. And I'll try my best to contribute to this and value add to all the participants here. IBC is a very important code, especially given the fact that the current juncture in which our country is there in terms of development and growth. And this will pave the way for the improvement in the credit market and broad-basing the credit market. So, though the work we do is very challenging, the ultimate benefit of the economy is immense, and that is what we need to understand. And today's topic is, in terms of the judgments that we are going to look at, a lot of insight and understanding to the participants will happen based on the discussion that will take place here. With that, I'll hand it over to Dweep to take it forward.
Hello everyone, good evening. And firstly, thank you to Ms. Dipti Mehta and the team at Mehta and Mehta Insolvency and Restructuring for inviting us for this fruitful webinars. And I believe and I hope that we all engage, learn, and collaborate as fellow professionals. And being a part of this esteemed panelist, I also want to whatever limited inputs that I can have on this topic, a very a broad perspective of the judgment that we can have on. And as far as IBC is concerned, I feel that currently these discussions, these webinars put in a very valid point of view wherein we can have this discussion of how can we revive in terms of what the geopolitical scenarios that are going in and how are they impacting our Indian companies and the other aspects of it. So I believe IBC is one of the mechanisms where it puts a lot as to the revival and to the functioning of the whole financial ecosystem of the company. So I hand it over to Urvashi, if you can just start with it for the limited time that we have.
Yes, sir.
Thank you. Thank you, Mr. Devarajan and Mr. Dweep. Yeah, Urvashi, you can start it now. And I'll request participant, if you have any question, you can put it on chat box. But at the end of the session, we will request that we will allow you to speak. And even the participants, our panelists will be giving their comments during the presentation, whatever they want to add on the value add. Okay, Urvashi, you can start this.
Good evening, one and all. I am Urvashi here presenting the recent reported judgments under the Insolvency and Bankruptcy Code 2016. Anil Kumar, Suspended Director, SK Elite Industries India Limited versus Jayesh Shankar Rajaka, RP SK Elite Industries India Limited. Withdrawing liquidation application and allowing a resolution plan after decision of liquidate the corporate debtor without issuing fresh EOI is commercial wisdom of COC and cannot be interfered in exercise of jurisdiction of judicial review either by NCLT or NCLAT in exercise of its appellate powers. Facts of the case: COC decided to withdraw liquidation application. The RP filed an IA before the adjudicating authority seeking withdrawal of liquidation application to permit COC to consider the resolution plan. The adjudicating authority kept liquidation application in abeyance and allowed the resolution plan of the respondent. In the 19th COC meeting, the resolution plan of the respondent was approved by 100% majority of the COC. The adjudicating authority, by its order, approved the resolution plan, having found the same to be in compliance with the provisions of IBC, the CIRP regulation, and not being in contravention with the provisions of any law. Decision of the appellate tribunal: when the COC has approved a resolution plan by 100% voting share, after considering its feasibility and viability, such a decision of COC is an commercial decision. There can be no feathers on the commercial wisdom of COC. It is a settled law that commercial wisdom of COC in approving the resolution plan is not to be interfered in exercise of jurisdiction of judicial review either by the adjudicating authority or by this tribunal in the exercise of its appellate powers. Having regard to the foregoing decision, according to the board, the adjudicating authority did not err in the approving of the resolution plan. In result, both the impugned orders do not warrant any interference. Appeals have been devoid of merit were dismissed.
Okay. Dipti, I just want to understand, the participants are all company secretaries or from variety of professionals here?
Variety professionals there.
Okay, fine. So you will have IPs
There
also
can be
here.
lawyers also, there can be C also, IP also.
Okay, fine. Right. So the point here, what we need to understand is that two things very clearly which comes out from here is that one is that Supreme Court has always held that liquidation is the last option. Now that is precisely why the NCLT decided to keep the application in abeyance, the liquidation application, and allowed the possibility of a resolution. One side of this. The second aspect is that the emphasis on commercial wisdom of the COC. So the commercial wisdom of the COC to take up this resolution in that sense where there is no EOI was subsequently issued and this resolution was taken up and approved because the EOI process has been gone through. There was no valid eligible resolution plan that came up, which could be considered. That is why liquidation was filed. So when the liquidation application is filed and a resolution has come up, the adjudicating authority thought it fit to allow it because of the jurisprudence on the subject. The Supreme Court has said that liquidation is the last option. Only one question that comes up in all these matters is that Supreme Court has also said that after 330 days, unless there is a very valid reason, you should not permit any resolution. The company has to go into liquidation. Now, this is a subject which is a case-to-case basis kind of a situation, which is decided by the adjudicating authority. So, because the Supreme Court has said both things, nothing after 330 days, and also said that liquidation is the last option. So, what is best under the circumstances decided by the adjudicating authority, and they accordingly allow this matter. So, two very important aspects need to understand. One, very clearly, the commercial wisdom of the COC has a great reach, and the adjudicating authority does not want to interfere. Second, the adjudicating authority will try for resolution, and if nothing is possible, they will only then permit liquidation.
Also, just to add, this goes with the furtherance of the purpose of which the IBC code comes into play, which I believe not just Supreme Court also has in various of its judgment has gone on to mention this provisional basis, maybe that this is what is required in the first instance as for the purpose of where the merits of the case is depending upon the merits of the case. Let's conclude this company with the part that it is getting revived, and that goes into furtherance of what the code itself has in its purpose. So I believe this wherein we say that the commercial wisdom is concerned, I believe what goes into play about the revival of the company is concerned, I believe every time wherein the liquidation is concerned, we have encountered a number of cases wherein and the last moment of the approval of the liquidation application, there have been certain provisional made by the adjudicators by themselves, stating that this is what is in the major benefit for all the stakeholders of the company, and where they have gone into this resolution plan rather than going into this liquidation. So I believe this is also in furtherance of what the code was meant for.
Thank you for inputs. Yeah, please go ahead.
Indotech Industrial Solution Private Limited versus Vishal Steels. Issue of pre-existing dispute in Section 9 application cannot be raised in appeal before the NCLAT when the corporate debtor has not taken any steps regarding filing of reply. Facts of the case: the Council of Appellants submitted that there was pre-existing dispute and OC has not disclosed the submissions in application, and they should be punished under Section 76. The CD had appeared in the proceedings in the year 2022. For more than a year, neither reply has been filed nor any steps were taken by the CD. The CD chose to watch the proceedings and took a chance. No objections have been filed by the CD. Decision of the appellate tribunal: the NCLAT was of the view that the adjudicating authority have found debt due and default has rightly admitted the application, and they did not find any substance in this appeal. Hence, the appeal was dismissed.
Very important thing, if you are not replying, not appearing, that means court says that you lose the right of appeal only straight away.
I believe this is a settled law which is provided in the text of the code, as well also to just provide one of the Supreme Court judgment that we rely on. Is one of the cases, I believe, Mobilox Innovations Private Limited, wherein Supreme Court has gone to the case wherein it is stated clearly that the adjudicating authority is not required to even consider the merits of the defense. Only a prior dispute has to be established. The communication made by the corporate debtor is fairly enough, and no merits need to be decided for this. So I believe this is a very settled law that the pre-existing dispute is always meant to be dismissed.
See, one important aspect here is that more important, Dweep of course cited the settled law in the matter. But if you don't exercise your right, then you'll be denied that opportunity later. That is a key takeaway from this judgment. Because you delay, you don't exercise your right, then you lose that right. So you may have a dispute which may be very genuine, but since you did not reply at that appropriate time, you have lost that opportunity. Please go ahead.
Yeah, please go ahead. Thank you. Yeah, Rush, you can proceed.
Mr. Saurabh Kumar Tikmani versus Talk Walkers Club System Private Limited. Interest-free advance granted by corporate debtor to its related companies are not classifiable under Section 45 of the Code. Instead of the loss of notional interest can be recovered from the directors of the corporate debtor as per Section 66 of IBC. Facts of the case: the applicant has claimed that the loan and advances were extended for a free of interest while the CD was incurring interest on loans obtained by the FCs. Accordingly, the applicant has computed notional loss of income on account of not charging interest on basis of 12%. The CD arising out of interest fee advances extended by the CD to its related companies at the rate of 12% per annum for a period of from the date of money was advanced till the date of realization to be in nature of undervalued transaction under Section 45 of IBC. Decision of the adjudicating authority: the bench was of the view that the amounts still being the property of the CD are receivable. Those transactions cannot be said to have been resulted into transfer of any assets of corporate debtor. Hence, the bench feels that these amounts cannot be held to be in nature of undervalued transaction under Section 45 of the Code. As regards claim of the notional interest being in nature of undervalued, the bench is of the considered view that grant of loans without stipulation of interest thereon per se cannot be said to be resulting into undervalued transaction. Grant of unsecured loan without stipulation of interest thereon is contravention to the Companies Act 2013, and such act can be said to be a fraudulent purpose under Section 66 of the Code. In the view of the aforesaid decision, the bench does not feel that the present transactions are classified under Section 45 of the Code. Instead, the bench was of the view that the loss of national interest, as claimed in the present petition, can be recovered from the directors of the corporate debtor as the contribution under Section 66 of the Code, because they were the person responsible for such fraudulent act of granting unsecured loan to the related parties. The IA is allowed in terms of aforesaid directions and disposed of accordingly.
Yeah, you can go ahead. Interesting that if a company is giving interest-free loan, even a good company, director is responsible. Very good lesson for directors who are working at present, that they have to be careful. They will be liable personally for this kind of extending funds to the group company without interest. Since it's a breach of under Companies Act also. Yeah, please go ahead.
See, the point here is that only one point we need to understand here is that the first thing is that a mistake was made. See, what is a transaction one need to understand? Here you made an application of a loans and advances which is your asset which you need to recover as an undervalued transaction. Actually, there is no transaction that has happened which is valued. It is basically money has been given, money has to come back. Interest has not been charged after a particular time. Right? So technically the application under Section 45 itself was wrong. So that is very important to understand that what is the correct application that needs to be made. Now, again, it is made to a related party, it is always looked at with a big lens to see whether there is a money siphoned off that has happened. That is why the court said also look at 66 on this particular transaction and look at it more seriously than just a question of an undervalue. There's no undervaluing here. It's the money that has not come, interest has not been charged, why it has not been done, what happened to the money.
For the context of the students who are appearing or who were attending this, Section 66 talks about the fraudulent transactions.
Yes.
And all those for the ones who are a bit no mention of that.
I think you clarified that because I forgot that there were students also here.
Yeah, go ahead, Rose.
Mr. Natwar Agarwal HUF versus SS Cash Developers and Builders Private Limited. An allottee in real estate project who subsequently becomes a decree holder under RERA Act 2016 continues to be a financial creditor in the class of home buyers and shall continue to be governed by the thresholder limit prescribed under section provision to section 7(1) of the code. Facts of the case: the corporate debtor did not execute agreement for sale as per section 13 of the Real Estate Regulation and Development Act, and hence aggrieved by the aforesaid conduct, the applicant was coerced to file a complaint before the Maharashtra Real Estate Regulation Authority under section 13 of the Real Estate Regulation Development Act 2016. The said complaint came to be heard by the Honorable RERA Tribunal, wherein the Honorable RERA Tribunal was pleased to pass the order in favor of the applicant. Decision of the adjudicating authority: the applicant cannot be allowed to claim eligible to file application under section 7 in terms of section 4 of the code, because if it is made permissible, it would paramount to circumventing the provision of the second provision of section 7(1) of the code. In other words, what is not permissible directly shall become permissible by RERA decree route. Accordingly, this bench feels that the present petition is hit by the bar under section provision to section 7(1) of the code. The bench was of the view that in such circumstances, the present case deserves to be dismissed under section 7 of the Insolvency Bankruptcy Code.
There's a very simple adjudication here, because the RERA, there is an already settled law, settled text of the court under 7(4), where it provides the minimum criteria of the allottees to file an application under section 7. That is either the 10% of the allottees or a minimum number of 100, whichever is less. So I believe this is a very standard adjudication, and no such. And also,
sorry, continue.
Also very important that finding a route via a decree route is also one of the observations that has been nicely put out here, because we Indians have this in us to find these routes and measures to go through one route or the other. So another observation wherein it clearly says, as in finding a route under RERA and then putting under section 7(1) through the minimum criteria route of 1 crore. That is a fit observation made here. So I believe it's a very, very straight observations.
We've only one question I have here.
Yes.
While we always say that anybody does not get something beyond what he already has.
Absolutely.
That is one aspect understood. But I want to understand one thing. There is a contract, there is a sale agreement, right? Based on which I have given money to the builder. Now, there is a provision there that if he defaults, I have the right to ask my money back. So the decree is a money decree. So when I get a money decree, my status of an allottee changes because I am no more interested in your flat. I want my money back. Now that aspect is not dealt with here,
Correct. And
so this is where this judgment I have an issue.
This is the lawyer in you talking.
No. See, the point is, I'm raising a question.
Absolutely, a valid question. But then, what I understand is, as seen the straitjacket view of stating you as the nature of what your transaction is, being the very character of your transaction being an allottee under the RERA, being under a real estate project. So I believe that is the whole eagle point of view of what has been taken under this judgment. But then, yes, always argumentative.
See, I can understand a decree holder cannot get a different status. If an OC remains an OC, if an FC remains an FC. But he is an FC. But the point is that he's not an allotee the moment he takes the money back.
Correct.
That is the issue that is not addressed.
Absolutely, sir.
Fine, sorry, go ahead.
Go ahead, yeah.
Nitin Chandrakant Desai versus Edelweiss Assets Reconstruction Limited versus and ANR. Any default committed during the Section 10A period cannot be held to be barred by CIRP application, which is filed on the basis of default prior to the Section 10A and subsequently to Section 10A period. Facts of the case: the appeal had been filed against the Order 25/7/2023, by which order of the adjudicating authority had submitted Section 7 application filed by the respondent. The adjudicating authority had held that the date of default is mentioned as 31/1/2020 in any SL certificate in the record of the default, and the above company petition filed on 26/7/2022 is well within the limitation. Certainly, the above date of default does not fall within 10A period, and the argument of the CD with regards to the default during 10A period needs to be rejected on merits. Decision of the appellate tribunal: the NCLAT held that the application indicates that default was committed by the corporate debtor prior to Section 10A period, and they are satisfied that no error has been committed by the adjudicating authority in admitting Section 7 application. There is no merit in this appeal. The appeal is dismissed.
I think case is very clear. Default during before and after that period is okay. You can go ahead, right?
There is a clarification provided in the text itself. A note 10A is provided for this.
Yeah. Yeah, go
See,
ahead.
in 10A, one or two points, Dipti, give me half a minute. In 10A, there are a lot of cases, a lot of issues are happening. And that particular 1 year period, of course, no application can be filed. Oh, that does not mean that you can never file an application. Always the banks and the financial creditors restructure your account, and then based on the restructuring, if you default, then based on that, an application can be filed. That is one thing that all the participants should know, because that is very important. Because many a times, and again, one thing which I'll point out here is that based on practical, what I've seen is that the NESL dates sometimes are incorrect. I've seen in the application that some other date is given, the NESL certificate is got a different date. Now, this is something that everybody should take care of. Otherwise, you lose a winning case. This happened in many cases. I've seen that, and the court would tend to rely on the NESL certificate or anything else.
So on this point of NESL certificate, I believe previously it was not mandated for many benches in the.
Now it is mandatory.
Yes, it is mandatory. So as per the practical point of view, for the ones who starting the practice out, in NCL Mumbai bench, NESL is one of the must-have things in your petition.
Thank you for the practical input. Thank you. Yeah, Rose, go ahead.
RKG Assets Management LPP versus MS Today Homes and Infrastructure Private Limited. The IBC does not mandate specific uniform criteria for imitation of resolution plans, and the Committee of Creditors is allowed to set its criteria on its own on a case-by-case basis. Facts of the case: the applicant was required to deposit amount towards the earnest money and performance security as per the said clauses. The present application has been filed by RKG Assets Management LPP, who is an investment manager of RKG Trust, a Category 2 alternative investment fund registered under with SEBI, seeking directions of the resolution professional who had issued request for resolution plan, that is RFRP document. The applicant's contention is that the said RFRP documents contain onerous and discriminatory clauses that have skewed the resolution process of the CD in favor of some resolution applicants, and thereby vitiated the resolution process. Decision of the appellate tribunal: it is noted that the applicant never raised any objections, either the COC or resolution professional, regarding the issues raised in the present application at the time of issue of RFRP. he applicant never raised any objections to the same and deposited a sum of rupees 10 lakh but did not submit the resolution plan. The bench was of the view that instant application bereft of merits and the same is dismissed.
So here is a case that where you don't have a cause of action at all here because you have not done what you're supposed to do earlier. So you delay, you don't exercise your right, then you lose later. Very simple. So you don't have a cause of action here at all. That's what the court is saying. And again, one other point here is that in any resolution, each case is different. So the eligibility criteria will be set tailor-made to that particular CD's requirement. That is something that cannot be contested also in that sense.
This is one input that I actually have. So as an RP, as for your experience, how was you in dealing, like what was the flexibility at your point of view in dealing with the COC or with the adjudicating authority? Was that flexibility there with you as just as a practitioner of the law?
Yeah, I will tell you very frankly, it's a question of the RP conducts himself with the COC.
Absolutely.
Now, many RPs take a view that I will go by COC for everything, including they go and try to tell them that this is the claim I've admitted, not admitted. It is not required actually. Send them the list of creditors, is enough. So the question is that if you don't, exercise your legitimate rights that have been given under the code, then you are not respected. Very important. Now, with the adjudicating authority also, the adjudicating authority is looking at you as the officer of the court. You are required to place everything before him and say why you have done something, why you have not done something. That is when you expect the decision in your favor. Otherwise, you will see that the opposite party is always there to say that the RP is the ill of the whole process. Unfortunately, the reason is like this. RP does not have any powers. Everything is decided by the COC, but the blame is on the RP. Why? Why I always ask this question, which is on the larger, broader perspective. See, when we take up an assignment as an RP, we are dealing with a set of unhappy stakeholders. Now, how you take them along is the key to this. Because you are a spoke in the wheel, an unwanted spoke in the wheel, unfortunately. Because these people are used to fighting with each other, sleeping with each other, being friendly with each other, divorcing with each other at every point of time over the last 20, 30 years. And you come into play and they say, now this man we have to deal with. And we have to basically listen to what he has to say, though he may not have any rights. But that is where the problem starts. You are an unwanted fellow. It's very similar. Dipti would know. When our profession started, CS profession in 1980, 84, every corporate looked at the company secretary as an unnecessary evil here. The point is that they never wanted him there. The acceptance took a lot of time, and now, of course, it is accepted. So this is the problem. You can't do much. There's more to do with human minds.
What I'm saying, the flexibility part has always been the question raised by this RP, stating, sir, ये code तो बोल रहा है, ये सब बोल रहे हैं, but the support that we require is never there. The scale code
there. In fact, to be very frank with you, just to share, in one of the matters, I told the bench very openly like this. I said, sir, as an RP, I'm already facing bullets from the creditor and the promoters. Now, the four pillars to support me, like the COC, the NCLT, the NCLAT, and the IBB and IPA, also start firing from behind. I have to die. I have no choice. I told them in these words.
Right.
Great.
There have been number of representations made nowadays also. Very frankly, there have been number of representations made very frankly to the bench by the RPs, stating, sir, we've been molested, we've been harassed, sir, and also you have made certain orders against me by this. So this is what I'm saying. So when it comes to flexibility of the operations, it is never the case for the RP to say that, sir, ये मैं criteria set करता हूँ, इस पे COC agree हो जाए.
Honestly, my thought is very simple, Dweep, here. The NCLT members have not understood the extent of problems and the work that the RP has to do. They feel तुम्हारा क्या काम है if the concern is not operational. They should come and sit on the chair and find out.
Sir, trust me, this has been the case for everyone.
Yes. So that is where the issue is. So actually, in the training program, this should also be one of the programs, you know.
Okay, I think Mr. Raji or Miss Raji has raised the hand. Yeah, you can speak, please.
एक होल्ड पे प्लीज अपडेट करो वो बाकी का हो गया बट जस्ट
I think by mistake they have done. Yeah, Urvashi, you can go ahead.
There is one of the comments from the totally.
He is telling they are agreeing with your view. Yeah, Urvashi, go ahead.
MS Pani Trading Corporation versus Mr. Jagdish Chandra B. Mistry. Resolution professional can reject the claim based on the records and audited books of accounts. Facts of the case: the present application is filed against the rejection of claim of the applicant by resolution professional RP. The resolution professional pointed out that as per the ledger account submitted by the applicant itself, interest was paid in the earlier years and no entry regarding the interest is made in the last years. The applicant has suddenly, on initiation of corporate insolvency resolution process, raised interest of multiple years in the ledger accounts. Decision of the adjudicating authority: it has been held that the resolution professional is given administrative as opposed to quasi-judicial powers. Resolution profession had rejected the claims of applicant based on the records and audited books of accounts, and his action in doing so cannot be faulted with. The application was rejected and disposed of.
This is always a whether rejection or not accepting.
See,
Insolvency or liquidation, I don't know.
No, I'll tell you one thing. See, actually, after that Supreme Court judgment saying that you're an administrator, and against the question of whether an RP is actually, exercising any skill in verification and collation of claims, the application of mind is there. You can't verify anything without, you say you are supposed to collate the claims, right? It is not a mechanical action. There is a point where you have to apply your mind to decide whether the amount is right or wrong. See, the question is that even the regulation says you have to, if you don't know what is the amount, you are supposed to estimate the amount. Now, when you estimate, there is a question of a skill that is involved, a judgment that is involved. Okay, that happens. Now, because of the judgment, all of us started writing claim admitted, not admitted, and under verification. So we didn't say it is rejected, it is not admitted. Now they can go to the NCLT and find out. See, my problem with these decisions are very different. There are a lot of cases where the interest is not provided by the CD. The books of the CD is not reliable. We all know that. Now, if there is a document submitted to me by a claimant which says that this carries X percentage of interest, that document is authentic, and you have given interest earlier, which is verified in the series book, but subsequently it is not provided for whatever be the reason, that document cannot be faulted unless you have correspondence of dispute or unless you have correspondence that the interest is not payable from so and so date. So now if I admit based on that particular contract, because we are supposed to verify based on the documents submitted and also based on the records available in the corporate data. Now, you cannot say that if that CD has not booked a particular interest, he is not eligible to get it. Or I cannot say now, okay, you go to the, my books have not provided, you go to the NCLT and take an order. Now, the question is that if you are going to estimate a claim, that estimation has to be based on the documents available with you. So to that extent, I of course humbly differ with this judgment, but the point is that.
Okay, thank you. Yeah, Urvashi, go ahead. And I think we have to speed up. It's 5:45. Yeah, Urvashi. Yeah, start.
Yes. Sanjay Kumar Mahakaria versus State Bank of India and ANR. Whether the CIRP application under Section 7 of the IBC filed by the State Bank of India, State Bank on the basis of recovery, certificate gave rise to a fresh cause of action for filing of application. NCLA facts of the case: by impugned order, an application filed by the respondent under Section 7 of the IBC for resolution of sum rupees 77 crores.
Whatever amount, go ahead.
Yeah, as on 30th 9/2022 has been admitted. Counsel of the appellant had submitted that the account was declared NPA on 11/7/2012, whereas the application under Section 7 was filed only on 27/10/2022, after more than a decade. Therefore, the application is barred by limitation in view of the fact that the application under section can be filed only within a period of 3 years, prescribed under the Article 137 of the Limitation Act 1963. The issue in this case is as to whether application filed by the respondent bank on the basis of recovery certificate issued to it by the DRT Hyderabad 1 gave rise to a fresh cause of action for filing of the application. Decision of the appellate tribunal: the Honorable NCLAT held that the aforesaid question is no more res integra, and it is hardly found that any merit in the present appeal. Therefore, the same was dismissed without any cost.
This is a very settled law that has been.
Yeah.
I believe there's a Supreme Court judgment also to. This does not hold relevance here because there is a Supreme Court judgment clearly stating that if there is an acknowledgement of debt or acknowledgement of the liability recorded in the balance sheet after even after 3 years, that acknowledgement itself is considered to be as a fresh cause of action that has been arisen, and that is also considered as within the limitation. And if you want, I can share the judgment also with the fellow attendees. We can do that in the chat box. But this is a very settled law.
Right.
Yeah, it's settled now. After a lot of judgments, it is settled now.
Absolutely.
18, 19, limitation and 18, 19, everything. No, more importantly, that is why it said is no more res integra. You know? That is very important to understand. This is already done and dusted so many times.
Just for the attendees who res integra just means that it has been decided on it.
In fact, I had we had an argument on NCLT on a decree like this, very similar, not from DRT but from the other court, and the limitation was argued for a long while, and then of course we got the decision in our favor. But the point is, it is well settled now.
Thank you. Yeah, Urvashi, go ahead.
Shripati Build Infra Investment Limited versus Abhiyan Developers Private Limited initially entered into an agreement for purchase of a flat and subsequently advance paid was converted into a loan, cannot charge the basic nature of transaction, and financial creditor will remain an allottee within the meaning of Section 2D of RERA Act 2016 is required to comply with the provision of Section 7(1) of IBC to initiate CIR. Facts of the case: the financial creditor entered into an agreement with the CD for purchase of a flat. As all the permissions and approvals was not sought properly, the CD was unable to commence the construction for the same. Subsequently, the said amount was converted into a loan account by the CD, and the same was repaid along with the agreed interest. However, no payment was received by the applicant in this regard. The CD filed an appeal before the Honorable NCLAT, wherein the NCLAT wide order set aside the order for admission and remanded back the case to the adjudicating authority to consider the objection of maintainability as required under the third provision of Section 7(1). Decision of the adjudicating authority: the applicant has not taken any steps to comply with the amended provisions of Section 7 of the Code, and the application is therefore deemed to be withdrawn before admission of the petition could have been filed jointly by not less than 100 allottees or less than 10% of total number of allottees under the same real estate project. So in the view of the above, the case is dismissed and not maintainable.
Yeah, go ahead.
It's very similar to the one earlier we discussed, that you can't get
It is exactly, that's why I said that
Yeah.
it's in the same line actually.
Okay. K.E. Ishwara Pillai versus Goods and Services Tax Department, search and seizures of records of corporate debtor and issuance summons to resolution professional by GST Department during CIRP are violation of moratorium under Section 14 of IBC 2016. Facts of the case and submissions. In the pursuance of CIRP order, moratorium under Section 14 of IBC 2016 was into operation effect. GST Department as an authority under the Kerala State Goods and Services Tax Act 2017 initiated proceedings against the CD during the period of moratorium. The raid was conducted and seized all the account documents and also sent a summons to the resolution professional to appear for inquiry. The search and seizure of records of corporate debtor and issuance of summons to the applicant resolution professional are violative to moratorium order passed under Section 14 of IBC 2016. This application was filed under Section 60 of IBC 2016 by the RP for directing the GST Department to release the assets which were seized and to initiate proceedings against the GST Department. Decision of the adjudicating authority. The respondent was directed to return all the documents seized from the premises of the CD to the applicant within a week from the order. The summons issued to the respondent to the CD is hereby set aside. The respondent is directed to pay a compensatory cost of rupees 50,000 to the applicant towards CIRP, and the respondent is granted considerability after paid supra compensatory cost to recover it from the erred officials.
So this is where the RP's interest is protected. At
Yeah.
14, you say you can't summon, you can't initiate any proceedings, only issue summons to the RP. Anyway, RP has been arrested. RP has been made a part of the FIR. All that is happening anyway with all this. But ultimately, the flip side is that the protection under 233 is somewhere getting recognized.
Yeah.
The RP is protected under the IBC.
Yeah.
So
Yeah,
as an
Joshi,
officer
go
of the
ahead.
court.
Yeah.
But here, of course, it is not the protection here because you cannot initiate any proceedings. How will you give a summons? That is why that fine has been levied.
Yeah, go ahead.
Bharatiya Kamgar Karmachari Mahasangh versus Miss Jet Airways Limited. Facts and submissions. The present appeal arises out of the judgment of High Court of Bombay, wherein it is confirmed that the award passed by the Central Government Industrial Tribunal, hereinafter referred as CGIT, rejecting the demand of the appellate tribunal for restrainment with a full back wages. The appellate contends that workmen were treated as temporary despite completing 240 days in service in terms of the model standing order provided under the Bombay Industrial Employment Rules 1959, and despite the nature of the work being permanent and regular. The High Court, while uploading the order of CGIT, held that mere completion of 240 days would not entitle the members to claim permanency under the model standing order, given the settlement and more specifically, Clause 18 thereof. It is further observed that the model standing order is not statutory provision, but at best is a statutory imposed condition of service that a settlement or an award can alter. Decision of the Supreme Court. A cumulative reading of the aforesaid clause reveals that a workman who has worked for 240 days in an establishment would be entitled to be made permanent, and no court or contract or settlement which abridges such a right can be agreed upon, let alone be binding. The Act, being the beneficial legislation, provides that an agreement or contract or settlement wherein the rights of the employees are waived off would not override the standing orders. The Supreme Court allowed the appeal holding the appellate union entitled to all benefits as per the Bombay Module Standing Order. The award passed by the CGIT and the judgment passed by the Honorable High Court of the Judicature at Bombay, affirming the same are quashed and set aside.
So one of the very, very good judgments here. I mean, a very beneficial one for the laborers, because we've seen many of the corporates trying to evade those payments by merely keeping them on contract basis for a prolonged period of time. I've seen personally for 1,000 days, still hiding under the root of these model standing orders.
Yeah.
So it's a very landmark judgment of the Supreme Court for the benefit of those laborers working under those industrials.
See, the contract workers, once they complete 240 days, have to be recognized as regular workers, is what is the key here. The second flip side, what we need to understand in IBC is that you cannot say for everything 238 applies, non-absence clause applies. The law of the land, the contract has to be recognized and has to be respected. That is a very important aspect that comes out here, which needs to be understood.
Yeah, Urvashi, go ahead.
Devendra Singh RP
Because
versus
we have to catch on now. It's already 5 minutes to 6, but we can
versus
still take 15-20 minutes. Okay.
versus Sanjay Rathi. GST department cannot appropriate pre-deposit of appeal towards tax liability of the corporate debtor. Facts of the case: the corporate debtor complied with an order of Honorable Customs Excise and Service Tax Appellate Tribunal, and the deposit amount of 1 crore as per pre-deposit amount in relation to the pending appeal. The Honorable Customs Excise and Service Tax Appellate Tribunal allowed the appeal. However, despite numerous requests from the corporate debtor or applicant, the respondents have failed and neglected to refund the pre-deposited amount. The applicant liquidator is therefore constrained to file instant application inter alia to direct the respondent to refund the pre-deposit amount of the CD. Decision of the adjudicating authority: after hearing both the sides and upon pursuing the above submission, the bench was of the considered opinion that the above application filed by the liquidator has to be allowed, directing respondents or the department to refer the pre-deposit amount with interest in favor of the CD within 2 weeks from the date of uploading of the order. Accordingly, the application is allowed.
The simple point is that once you have filed a claim, then you're not entitled to adjust anything against that. If you have something else of the CD with you, that will amount to preferential payments. As simple as that.
Right.
Go ahead, go ahead.
Yeah.
Pratim Bayal versus Tata Motors Finance Solution Limited. Check issued prior to CIRP admission and encashed during CIRP cannot be termed as preferential transaction or violative to moratorium under Section 14 of IBC. Facts of the case: the erstwhile management of the CD had issued a check in favor of Tata Motors, was admitted against the CD. The resolution professional, the applicant, via his email called upon the respondent to refund the said which was illegally encashed. However, the respondent refused to refund the amount and he instead attempted to justify the illegal encashment. Despite moratorium, the respondent, that is Tata Motors, encashed 2 checks that were issued by the CD, which was well within the moratorium period. Therefore, it is submitted that a transaction may be considered as a preferential transaction as the subject encashment is in complete violation of Section 14 of IBC, seeking refund thereof along with interest in CIRP account. Decision of the adjudicating authority: the payment of check release subsequently relates back to the receipt of check, which is instant case appears 8 January 2022, and since the moratorium was declared on 12 January 2022, this transaction in view of ratio of Olge glass works does not violate the moratorium. Therefore,
very important judgment for this IPs, because this they face that the check is already issued and then it is not encased, it get encased when during the CI period, and what is the situation, whether this should allow, they should not allow, if the check is already issued. So it's really very helpful, this judgment, to decide that how the RP should behave and how it should be treated. Honestly, it's a big deal. Yeah.
Therefore, in the considered opinion, this transaction cannot be termed as preferential or violative to the moratorium, and accordingly, the IA is rejected. Bank of India versus Sri Rajeshwara Nanda. Just a minute.
Yeah, Paper Mills Limited. Go ahead.
I can't see actually.
Yeah, it is Bank of India versus Sri Rajeshwaran Paper Mills Limited. You start the decision.
Just a minute, ma'am. Yeah. NCLT directs the suspended management of the corporate debtor to appear in person. In case of non-compliance, the only recourse left would be issuance of either bailable warrant or non-bailable warrant. Facts and submissions of the case. This application is filed by the RP. By the Learned Counsel of the RP submits that the compliance of the order dated 19/6/2023, he has filed an affidavit giving status report onto the factory premises when the ex-IRP had visited on initiation of corporate insolvency resolution process. It is pointed out that notices were issued and duly served to the respondent, but even thereafter, no one appeared for the suspended management to explain the conduct and allegations as narrated in the application. Decision of the adjudicating authority, after considering the facts of the adjudicating authority, was of the opinion that the personal presence of suspended management is necessary to ascertain some facts thereof, directs the respondent's suspended management to appear in person either physically or through virtual mode and to place their say on the matter. It is made clear that in the case of non-compliance, the only recourse left would be issuance of either bailable or non-bailable warrant.
Okay, go ahead.
Okay, so
now disciplinary committee.
Yeah, so orders passed by the disciplinary committee in the matter of insolvency professional under section 220 of the Insolvency Bankruptcy Code 2016, read with regulation 13 of the IBBI regulation 2017. Contravention 1. Prescribing non-refundable participation fees. It was observed by the board that the liquidator IP had prescribed a non-refundable participation fees of 25 lakhs in addition to the earnest money deposit, that is the EMD of 5 crore in the e-auction process during liquidation. The board had also observed that failure to the first two e-auction process due to requirement depositing a non-refundable participation fee of 25 lakh must have led to lowering the reserve price, resulting into a lower recovery and thereby contributing to reduction realization. Submissions of IP. IP submitted that there is no material on record or evidence to suggest that because of prescription of non-refundable participant fee, the auction could not fructify. The failure of the auction was due to economic consideration and not as a result of imposition of participation fee, which in any event was minuscule fraction of reserve price and which had not only been prescribed in consultation with the SCC but was perfectly in consonance with the law as it prevailed and the relevant time. Analysis and finding. Conducting the new valuation post commencement of auction of assets of the CD further burdened the already stressed CD, and being a professional, the IB should have guided the SCC correctly about the provisions of the code regulations framed thereunder. Further, in terms of liquidation regulation for the third e-auction, the reserve price can be reduced up to 10% only, whereas the IP reduced the reserve price for the third e-auction by 25%. The DC finds that the IPS liquidator has failed to act as per the regulation 35(2) of the liquidation regulation, read with clause 13 and 14 of the code. Contravention 2. Delayed valuation during the liquidation process. The IP had appointed valuers, namely RNC Valicon LPP and Protocol Valuers Private Limited, for the purpose of conducting the valuation of CD via engagement letter dated 7 November 2021, that is more than 2 years of liquidation commencement date. Submissions by the IP. There had been a change in the circumstances from the insolvency commencement date by virtue of the fact that several assets of the CD had been utilized for the execution completion of project undertaken by the CD. This utilization of assets and consequent completion of project would have usually impacted the valuation of CD in interviewing period of the last 3 years. Analysis and findings. IP should have guided the SEC correctly about the provisions of the code and regulations framed thereunder. Mr. Sinha reduced the reserve price for the third e-auction by 25%. Had Mr. Sinha followed the liquidation regulation correctly, the assets of the CD could have been put to an auction at reserve price. The DC finds that the IPS liquidator has failed to act as per Regulation 35(2) of the Liquidation Regulation Act, read with clause 13 and 14 of the code. Contravention 3. Fees of BDO Reconstruction Advisory LPP. The board had observed that the IP appointed BDO Reconstruction Advisory LPP, where the IP is a partner. Oh God, what happened? Where
This
the IP
we have
is a
taken
partner.
earlier cases, right? Because that now we have, or May 23 and we are in August. So more
Yeah,
than
ma'am.
15 days, yeah.
Yeah, where the IP is a partner for providing support service in the liquidation process of the CD, considering the fact that the IP is one of the partner of BDO engaging such an entity for rendering support services at such an exorbitant cost, not only puts an additional financial burden on the already stressed entity for rendering company, but also exhibits lack of objectivity, enabling provision in the code and regulation allowing the appointment of professionals by liquidators are for the purpose of helping him in managing process of liquidation, engaging an entity of which liquidator is a partner and paying them such exorbitant fees for support services is not unjustified but also malified. Submissions by the IP. In the 16th meeting of the COC, the members of the COC unanimously agreed that the fees of the support service of the liquidators shall be decided by the liquidator in terms of the provision of the IBC. The IP further submitted that in certain situations, some projects had been completed but required follow-ups for total closure with the regard to receivables company or lenders, either in cash or in form of enclosures of bank guarantee provided for such projects. In view of aforesaid, the IP submitted that there has been no violations under Regulation 7, Liquidation Regulation, read with clauses 1, 2, 14, and 25 of the code. Analysis and findings. The DC notes that the IP must ensure that not only fees payable to him is reasonable, but also other expenses incurred by him are reasonable. What is reasonable in context of specific? It is not amenable and precise to a definition. The term reference of work and the remuneration are needed to be spelled in every contract clearly to dispel any suspicious on the ground arbitrariness and unreasonableness. Order, the disciplinary committee suspends the registration of IP for a period of 1 year.
How many are there, Urvashi? Because
Five.
Only one point in this disciplinary order I would like to share. See, that whole facts of the case are very subjective, and he has gone to the SEC, SEC is approved. Of course, he is a related party, fine. So the point is, when there is subjectivity element, how do you decide what is material, what is not material? That is where the issue is. And then you suspend, a very severe punishment is given. And this is what we have taken up with IBBA also on many occasions. That if you want to levy or, a fine or anything, look at the materiality. Is it material to the process or is not material to the process? Accordingly, decide the fine.
So what just you mentioned, so we just had this hearing before the High Court against this IBBA order that we had put in a stay for this order for one of the RPs. There, the High Court has very, very frankly mentioned to the IBBI, are you colluded with the other RP who has been filing this complaint against you, this RP, the one you were fighting for? So what even High Court has raised concerns stating that IBBI is colluded with other parties who initiate such inquiries or have these penalties levied on the RPs for such meager reasons. So this is what has been taken by the High Court also very seriously. Also,
Yes.
This has to be considered very strictly, I believe. And IBBA has to consider that the RP's subject point of view is because RP, as we mentioned, has been attacked by all the stakeholders. You need certain support system from somewhere.
No, the point is IBBA cannot attack anybody else, no? They can't attack the COC members. They can't do anything else to anybody. They can only regulate the IPs.
The very, very stringent methods are taken here.
Okay. Yeah, Roshi, go ahead. Still
the matter,
cases or how many cases?
there are, this is the 4, I guess this is the second one, so 3 more, ma'am.
If we
I
can
think
take
we'll
up
close
the-
with this.
Yes, if we can take up the questions from the audience.
Yeah, or otherwise we can close and we can take up a
Yes.
question. We can take this disciplinary cases in next session.
Sure, ma'am.
If any question or discussion.
Yes, ma'am.
Keep it open 5 minutes, 10 minutes.
Yeah.
15 is already done.
Okay, ma'am.
Yeah, participants, if you have any question. I think all participants, they have what comments. You people has given enough comments to all the decided cases. And I think the very lucidly Urvashi has presented each cases. So if there is no question, then I think we can close this session. And thanks, Mr. Devarajan, for your time.
Thank you very much.
For comments, sharing the experience and your comments. Mr. Dweep, thanks for sharing your practical tips and all the thing and sharing your time. I really respect your contribution and time. Thanks a lot. Thanks entire participants for this your quiet presentation presence, and I request you to join in next 15 days with another webinar series. Thank you, everyone. Yeah, Mr.
Thank you,
Devarajan.
Dipti. Thank you, Dweep. Thank you, President Urvashi.
Urvashi.
Yeah, thank you, Urvashi. So it was a nice experience, and thank you, everybody. Because in the process, we also learn, a few things. And otherwise, you don't always take pains to read all the judgments. So this serves an occasion to really go through things, and that's quite helpful.
Yeah, thanks,
Thank you.
everyone. Thank you. Yeah, Mr. Dweep. Yeah.
Just thank you note for Urvashi and your thank you so much.
Thank you.
Thank you, sir.
Thank you.
Mr. Devarajan.
Bye. Thank you.
Mr. Dweep. Thanks all the participants. Thank you.
Thank you.
Bye.
Bye.